Hey guys, my name is Joel Williams. I'm a personal injury attorney in Kennesaw, Georgia. Today I want to talk to you about mediation and how it might be appropriate in your personal injury case. If this video was helpful to you, we'd appreciate you subscribing to our page so you'll be the first to get notice of new videos, and maybe even sharing it with your friends. If you have any comments, just insert them into the comment section below and we'll be sure to respond. Now, personal injury claims can settle at any time. For example, some will settle before a lawsuit is even filed. This is called the pre-suit stage. Some settle shortly after a lawsuit is filed, and yet others will settle just before the eve of trial. Mediation is just one tool in the process of a personal injury claim that lawyers use to try to help get cases settled. Some cases will settle pre-suit. Mediations do occur then, but it's fairly rare. Most often, mediations occur after a lawsuit has been filed and the discovery process is over. Now, what is a mediation? A mediation is basically a formal settlement conference. Most mediations occur before a neutral or a person who is often referred to as the mediator. The mediator is usually a retired judge or an experienced lawyer who's done this for a very long time and wants to come in and help other parties get their cases resolved. One important thing to remember about a mediation is that the mediator or the neutral can't make anybody settle their case. All they can do is encourage you and speak with you, as well as your opponent, about the strengths and the weaknesses of your case, the risk and the benefits of moving forward or settling. Now, most mediations start out in what's called a general conference. That's where both sides go to one room with a mediator, and usually starting with the plaintiff's lawyer will begin to tell the strengths of their case, and they'll also discuss the weaknesses of the defendant's case. The defense lawyer will do the same, and both sides will be able to hear the theory of the other side's case, so they'll be better prepared to understand the position of their opponent as they enter into formal negotiations. Now, after this general conference, the two sides usually split up and go into their own separate rooms. At that point, the mediator usually goes into one of the parties' rooms to discuss the case and get an initial offer. After he or she has gotten that initial offer, the mediator would go back and forth between the two rooms discussing the case, risk, benefits, new information that's come to light, and then he or she will take offers back and forth to see if he can get the case settled. Now, whether the case settles depends on whether the least amount that the plaintiff will take is less or equal to the most amount that the defendant is willing to pay. That's a mouthful. So imagine you go to a car dealership and you see a sticker price on a car. Well, you know that you're not going to have to pay the sticker price on the car. But when you make an offer to the salesman, that salesman knows that your first offer is not the most you're willing to pay. Cases will settle if the most the defendant's willing to pay is equal or more to the least amount that the plaintiff is willing to accept for his or her damages. So, if we take the car salesman example and apply it to a mediation, imagine the plaintiff is the car salesman and the defendant is the car buyer. If the plaintiff is willing to accept the most that the defendant or the car buyer is willing to pay, then the case will settle. Of course, not all cases will settle at mediation, and if they don't, the case will move forward towards trial. But mediations have a high success rate because we know what cases have settled for in the past. Most good attorneys are well adept at analyzing the risk for their client to determine what a reasonable settlement value is. Now, one question I get from my clients before mediations is, are we going to have to testify? Or are we going to have to say anything? And the answer to that question is answered on a case-by-case basis. Sometimes it's appropriate, but most of the time it's not. And the client's job at mediation is to make the final call on the numbers and what they're willing to accept after hearing the attorney and the mediator's suggestions and advice. If you've been injured due to the negligence of someone else, be sure and give us a call here at Williams Elleby for a free consultation. Our phone number is 833-LEGAL-GA, or you can find us on the web at gatrialattorney.com.